Your freedom is at stake when you go to your arraignment. The government may want to try to hold you in jail. In this video, we'll discuss what to expect at your arraignment and how to protect your rights. Your arraignment holds many risks for you. The government is trying to take you from your normal life and forcing you into the criminal justice system. You didn't want to be on this journey. It's been forced upon you. Besides all the other stress, you're wondering how is this going to affect your job and your family. You know you need a lawyer, but you're not sure you can afford one. At Afford Law, our fees are based on your income, so the less you make, the less you pay. Working together, we'll guide you along this dangerous path. You can get through this. Better days are ahead when you can go back to the life you once knew. What is an arraignment? Well, an arraignment is the first step in the criminal justice process where a record is created. At an arraignment, you are placed before the court and told officially what the charges are against you. You may have had a clerk-magistrate's hearing before the arraignment. There was no record that was made at the clerk-magistrate's hearing, so the arraignment is the first time that a record is made. The importance of that is, once you go to arraignment, you now have an entry on your criminal record. If you are arrested and held in custody, you'll be brought to court the next time the court is open. Or perhaps you've been summoned to go to court. That's where you get a notice in the mail to report to the court on a certain day. On the day of arraignment, you should dress appropriately and arrive to court on time or a little bit early. When you get to the courthouse, you want to check in with the probation department. The probation department will do an intake. They'll take your name, some information such as your address, date of birth, have you ever been arrested before, do you have any open cases? There are a number of things that the probation officer is looking for, including confirming that you are in fact the person to be arraigned. They will determine if you have a criminal record, and they'll look to see if you have any outstanding warrants. In addition, they want to see if you qualify for a court-appointed attorney. If you are a veteran, you want to make sure you tell the probation department, because there is such a thing as the BRAVE Act in Massachusetts. The BRAVE Act is something that can help a veteran who finds him or herself in the criminal justice process. If you qualify, you could be diverted into what's called a diversion program, which takes you out of the justice system and into this diversion program. The important thing is to notify the probation department so that you can be diverted into that program prior to arraignment, therefore saving you from having a mark on your criminal record. After checking in with probation, just take a seat in the courtroom and wait for your name to be called. At some point, the clerk will call your name. You go up before the judge. The clerk will read the charges. They'll tell you the date where the crime allegedly took place, what police department is involved, and what the crime is exactly. Not guilty pleas will enter on your behalf. They will ask you what you want to do about a lawyer. Are you going to represent yourself, hire an attorney, or do you want to ask for a court-appointed attorney? They will also give you a bail warning. A bail warning is basically they put you on notice where they say that while you have an open case, if you get rearrested for any new matters, your bail on that case can be revoked and they can hold you for up to 90 days. Before we discuss how the Commonwealth can hold you in jail at your arraignment, I just want you to feel free to give us a call if you have any questions regarding criminal matters in Massachusetts. It's very important that you get an attorney on board as soon as possible. At Afford Law, our fees are based on a sliding scale based on your income. So the less you make, the less you have to pay. Now let's take a look at what are the dangers of going to an arraignment. The first way the Commonwealth can try to hold you in custody is on bail. They may ask the judge to set bail on your case. Keep in mind that the purpose of bail is simply to ensure that you show up for all of your future court dates. Bail is generally cash bail. That means if they set $500 cash bail, you need to come up with $500. There are no bail bondsmen in Massachusetts. If bail is going to be an issue in your case, you'll hear the Assistant District Attorney tell the judge that there is a question of bail. That's going to be the phrase that they use. The ADA will take a look at the police report, your criminal record, and information that was gathered from the probation department interview. When deciding whether to set bail and in what amount, the judge will look to many factors. Some of the most important factors are your history of defaults. If you have a criminal record, have you not shown up for court in the past? That will make the court think that you're not likely to show up for this case in the future. The court wants to see if you are a flight risk. They want to take a look at your ties to the community and looking at your history of consistent employment. If bail is a question, bail arguments will be made on the day of arraignment. That's where the Commonwealth basically makes an argument why they feel bail is appropriate in your case and in that amount that they're asking for. Your attorney will ask that you be released on PR or personal recognizance. That means that you don't have to pay any money to be released, and you promise to appear for all your future court dates. If bail is set on your case, you have the right to a bail appeal. That means that you can take that decision to the Superior Court and ask a different judge to lower the bail to something you can afford, or perhaps even personal recognizance. In addition to bail, the Commonwealth can ask for conditions of release to be placed upon you. If there are conditions of release, that means you have to do or not do certain things while you are out. Some common conditions of release include to remain drug and alcohol free with random testing, to stay away or have no contact with certain people, and a GPS to know where you are and to give you an exclusion zone for where to stay away from. A violation of these conditions of release can also lead to jail on your part. So let's just say that you have a no contact order against a specific person. If you violate that no contact order, you can be brought back to court and can be accused of violating your conditions of release. At that point, the Commonwealth can now ask that your bail be revoked and that you be held in jail on that condition. Another way the Commonwealth can hold you in jail at your arraignment is through what's called a dangerousness hearing. If that happens, you can be held for up to 120 days without the chance of being bailed out. There are two stages to a dangerousness hearing. The first is the initial phase, or the initial hearing. That's what happens at the time of arraignment. Basically, the Commonwealth has to prove two things at this stage. The first is that you committed a predicate offense, and the second is that there is probable cause to believe you committed that offense. The first thing the Commonwealth has to prove at this point is that you have been charged with a predicate offense. And that just means that one of the charges that you're facing falls under the heading of the dangerousness statute. Those crimes are typically crimes of violence, but they can also be things such as operating under the influence, subsequent offenses. So that's the first thing. The second thing the judge has to be convinced of is that there is probable cause to believe that you committed this offense. Probable cause is a very low standard, and the judge almost always finds that probable cause has been met. If the Commonwealth is successful at this stage, you will be held until a full hearing can happen under the dangerousness statute. You'll be held for 3 to 7 days before returning to court for that full hearing. At this hearing, there are two things the Commonwealth has to prove to the judge. First is that you are indeed a danger to the community or to a specific member of the community. And the second thing is that there are no less restrictive means to protect the community except holding you in custody. Now, less restrictive means can be a number of things. They could be house arrest, you could be put on a GPS, they could order a scram unit. A scram unit is basically a portable breath test that you carry around with you, and you have to blow in a number of times a day. The court can also order a stay away, no contact order if they're convinced that you would abide by that order. Otherwise, if the judge finds that you are a danger and there are no less restrictive means to protect the community, they can hold you for up to 120 days. When making that decision, the judge considers many things, such as the seriousness of the crime, what are your family ties. The judge will look to your work history as well as any mental health issues. And one of the most important things is your criminal record, if any. The decision by a judge to hold you as a danger is not appealable. Another way you can be held in custody at your arraignment is through a probation detainer. A probation detainer happens when you are on probation for one case and you pick up a new charge, and that's why you're before the court for arraignment. In addition to just being presented as a violator, the probation department is asking that you be held in custody until your probation violation hearing. Bail revocation is another way that you can be held in custody at your arraignment. What is a bail revocation? Well, what happens is if you have an open case already, so you've been charged somewhere else in Massachusetts for a crime and you have that open case. Now you've been arrested and charged with a new case. At the time of arraignment, you were given the bail warning, which says if you get rearrested while you have this open case, the Commonwealth can move to revoke your bail. Well, that's what they're trying to do. The Commonwealth has to prove 3 things in order for you to be held on a bail revocation. The first is that you were given the bail warning at the original case. The second is that there's probable cause to believe that you committed the crime you are now being arraigned upon. And the third is that you pose a serious danger to the community or to a specific member of the community. If the judge revokes your bail, you can be held for up to 90 days without the chance of being bailed out, and that decision is not appealable. What happens after the arraignment? Well, at your arraignment, you'll be given a date to come back for the next court date. That will probably be for a pretrial conference. A pretrial conference is a chance for your attorney and the district attorney to discuss your case to try to move it forward. You are now in the discovery mode, so your attorney may be looking for additional documents or evidence that the Commonwealth has pertaining to your case, which could be helpful. Your attorney may file motions to suppress, motions to dismiss, or a whole host of other types of motions. At some point, you'll discuss with your attorney whether you should accept a plea agreement or take your case to trial. Your arraignment is a critically important step in your case. Many decisions are made on this one day that can have enormous consequences for you and your family. The government could send you to jail for many reasons on this day. We don't want you to have to defend yourself because you think you can't afford an attorney. Our fees are based on your income, so the less you earn, the less you pay. Call today for a free virtual consultation. And for more information on criminal matters in Massachusetts, please feel free to visit our next video.